Ms Legalista here. Thank you for joining the video. Let me turn my phone off, but I can see it right here, and I can always pause the recording in case I need to take a call. Thank you for joining. We are back to the Sperlings, and I don't know if you have been watching Clipped. I think that's the name of the series that's on Hulu or HBO Max. I don't even know because I just click on Hulu and there it was, and I think that's what it was. In any case, it speaks to having good actors because this really actually could be a really bad series. But I think it is done really well. It's entertaining and it keeps my attention. But it also has so much legal stuff going on with it. I thought now might be a good time to dig back out some of those complaints and filings, and maybe even a tape recording that we heard in the past a number of years ago about Donald Sperling. So we're going to look at Donald, Rochelle Sperling, his wife. These are the former owners of the Clippers. And yes. We're going to start with her complaint where she goes after all of those things that he gave V, his assistant, and I think it's Stiviano. This is the lawsuit. If you have been looking at this series on Hulu, and that point in time where she gets served, I think she's up maybe in the box watching the game. It looks like that's where she is, where she gets served these papers. So now let's take a look at what those papers looked like in real life. We have an idea of what the papers said because of course, everything this happened a few years back, so everybody's seen all that. But if you've been watching the movie and you're now sort of like, well, what exactly did those papers say? These are the papers for real. And sorry to go on so long here. Let's jump into this. You can see this is coming out of Superior Court of the State of California for the County of Los Angeles Central District. Let's scroll down just a little bit here. Look at this. Look at this. Look at this. Rochelle H. Sterling, as a married woman seeking to protect and recover community property in her individual capacity. She is the plaintiff. V. Stiviano, aka Vanessa Maria Perez, aka Monica Gallegos, aka Maria Monica Perez Gallegos, aka Maria Velez, an individual and all persons unknown, claiming any legal or equitable right, title, estate, lien, or interest in the property adverse to plaintiff's title or any cloud on plaintiff's title to the property, and does 1 through 5, meaning any other parties, inclusive. That's everybody. Those would be the defendants. Let's see. We have a verified complaint for number 1, set aside of community property without spousal consent. 2, conversion of community property. 3, constructive trust of community property. 4, common count for community property had and received. Number 5, unjust enrichment. Number 6, accounting of community property. Number 7, to quiet title to community property. Number 8, reformation of deed. Number 9, declaratory relief. Number 10, declaration that gifts of community personal property are void. And you can see there a jury trial was demanded. Plaintiff Rochelle H. Sterling, a married woman and the wife of Donald T. Sterling, he will be D. Sterling, alleges as follows. As you can see here, plaintiff is a California resident who resides in LA County. She has been continuously married to D. Sterling for over 50 years. At all relevant times alleged herein, plaintiff has been married to D. Sterling. Plaintiff is informed and believes and thereon alleges that defendant V. Stiviano, aka Vanessa Maria Perez, Monica Gallegos, Maria Monica Perez Gallegos, and Maria Valdez, represents herself to be a single woman who, at all material times alleged herein, was an individual residing in or doing business in LA County. Plaintiff is unaware of the true identity, nature, and capacity of each of the defendants designated herein as does 1 through 50. Plaintiff is informed and believes and thereon alleges that each of the defendants designated herein as a doe defendant are in some manner responsible for the damages and injuries that are alleged in this complaint. Upon learning the true identity, nature, and capacity of the Doe defendants, plaintiff will amend this complaint to allege their true names and capacities. Plaintiff is informed and believes and thereon alleges that at all times mentioned herein, each of the defendants designated as Does 1 through 50 was an agent or employee of each remaining defendant. Plaintiff is informed and believes and thereon alleges that at all material times herein, each of the defendants was the agent, servant, and employee of each remaining defendant, and in doing the things herein alleged, was acting in the course and scope of said agency and employment, with the permission and consent of his, her, or its co-defendants, and is responsible in some manner for the acts alleged herein, and thereby proximately caused injuries and damages to plaintiff as alleged herein. General allegations. This lawsuit involves the activities of defendant Seviano, who plaintiff is informed and believes and thereon alleges engages in conduct designed to target, befriend, seduce, and then entice, cajole, borrow from, cheat, and or receive as gifts transfers of wealth from wealthy older men whom she targets for such purpose. Plaintiff is informed and believes and thereon alleges that one such target was D. Sterling. Plaintiff is informed and believes that and thereon alleges that at all times material hereto, Stiviano knew that D. Sterling was a married man, and that the transfers of property and money by D. Sterling to defendants was done without the knowledge, consent, or authorization of his wife. Plaintiff is informed and believes and thereon alleges that defendant Stiviano was first introduced to D. Sterling at the February 2010 Super Bowl game. Plaintiff is informed and believes and thereon alleges that commencing in or about 2010 and continuing through the present date, defendant Stiviano initiated and participated in a sexual relationship with D. Sterling. Plaintiff is informed and believes and thereon alleges that commencing in or about 2010 and continuing through the present date, without the knowledge, consent, or authorization of plaintiff D, Sterling transferred significant community property, assets, and monies of plaintiff and D. Sterling to and for the benefit of defendant Stiviano as part and parcel of their sexual relationship. Defendants acted willfully and maliciously with the deliberate intention to injure and damage plaintiff by obtaining and receiving money and assets known by defendants to be the community property of plaintiff and D. Sterling, with the knowledge that plaintiff had not consented to the transfer of community property to defendants. The full extent, nature, and amount of community property funds and assets transferred by D. Sterling to defendants without the authorization or consent of plaintiff is presently unknown to plaintiff, and an accounting of same is required. Plaintiff did not consent to the transfer or gift of any community property funds, assets, or property to defendants, or any of them at any time in any amounts whatsoever. By this complaint, plaintiff seeks to recover for the benefit of the community all community property and the profits therefrom transferred by D. Sterling to defendants. Plaintiff is informed and believes and thereon alleges that before filing this complaint, D. Sterling made demand on defendant Stiviano to return the property and all community property assets transferred and gifted by him to her, and that defendant Stiviano refused to return the property and assets as demanded. First cause of action to set aside transfer of community property without spousal consent against all defendants. Plaintiff hereby incorporates by reference each and every allegation contained in paragraphs 1 through 12 as though fully set forth herein. Plaintiff is informed and believes and thereon alleges that commencing in or about 2010 and continuing to the present date, D. Sterling regularly provided community property funds to defendant Stiviano that were used to pay for her upkeep and living expenses, believed to be in an amount of not less than $240,000. And D. Sterling purchased for Stiviano with community funds various assets, all of which are presently unknown, but believed to include a 2012 Ferrari automobile, two Bentley automobiles, and a 2013 Range Rover. The total value of said automobiles are believed to exceed $500,000. Defendant Stiviano and defendants Does 1 through 50 are wrongfully in possession of said community funds and property and all assets purchased with said community funds, and have converted said community property funds and assets to their own use. Plaintiff did not consent to the transfer or gift of any such community property funds, assets, or property to defendants or any of them at any time in any amounts whatsoever. Plaintiff is informed and believes and thereon alleges that in or about December 13th, D. Sterling transferred at least 1.8 million of community funds to or for the benefit of defendant Stiviano to acquire a duplex located at 8437 West 4th Street, Los Angeles, California. The property, with the understanding that the property would be owned by the community and title would vest in the name of plaintiff and D. Sterling. Plaintiff is informed and believes that D. Sterling either gifted said property to Stiviano without the knowledge, consent, or authorization of plaintiff, or in the alternative, Stiviano fraudulently and wrongfully caused title to the property to vest in her name. Stiviano and Does 1 through 50 are wrongfully in possession of the property and have converted the property and the community property funds used to purchase the property by their wrongful acts. Attached hereto as Exhibit A and incorporated herein by this reference is a true and correct copy of the grant deed to the property recorded on December 9th, 2013, reflecting legal title to the property is held in the name of V. Stiviano. Plaintiff is informed and believes and thereon alleges that defendants Does 1 through 50 conspired with and assisted defendant Stiviano to acquire and convert the community property of plaintiff and D. Sterling. Plaintiff requests that the court set aside all transfers of community property by D. Sterling to defendants made without the consent or authorization of plaintiff as alleged above, deem defendants constructive trustees of such community property, and require defendants to return all such community property, all assets acquired with such community property, and all profits and rents therefrom to plaintiff on behalf of the community. Second cause of action for conversion of community property by all defendants. Plaintiff hereby incorporates by reference each and every allegation contained in paragraphs 1 through 17 as though fully set forth herein. On or about 2010 and continuing through the present date, defendants and each of them converted the community property of plaintiff, including without limitation, A, funds believed to be in excess of 1.8 million provided by D. Sterling to purchase the property. B, the property valued at 1.8 million. C, a 2012 Ferrari, two Bentley automobiles, and one 2013 Range Rover automobile purchased with community funds provided by D. Sterling worth in excess of $500,000. And D, additional sums of community funds in an amount believed not to be less than $240,000 provided by D. Sterling to defendant Stiviano and used by defendants to pay their living expenses and to acquire additional assets presently unknown to plaintiff. Plaintiff is informed and believes and thereon alleges Doe defendants 1 through 50 conspired with defendant Stiviano to convert the community property to plaintiff and or to transfer said community property to others whose identities are presently unknown. Plaintiff has suffered and continues to suffer damages in an amount to be proven at the time of trial, but believed to be in excess of $2 million. At the time of each conversion, plaintiff had the immediate right to possess the property based on the payment of the purchase price with community funds, and the immediate right to possess all funds and assets transferred by D. Sterling to defendants by virtue of the fact that such funds and assets were the community property of plaintiff and D. Sterling. As a direct and proximate result of defendant's wrongful acts, plaintiff has suffered and will continue to suffer damages in an amount to be proven at the time of trial, but believed to be in excess of $2 million. Third cause of action, for imposition of a constructive trust against all defendants. Plaintiff hereby incorporates by reference each and every allegation contained in paragraphs 1 through 23 as though fully set forth herein. The facts alleged above require the imposition of a constructive trust against defendants with respect to the property because plaintiff has a community property and ownership interest in the property that was subverted by the gift of such property by D. Sterling to Stiviano without plaintiff's consent or authorization, or alternatively, by reason of defendant's act in wrongfully or fraudulently causing title to the property to vest in the Stiviano's name. By engaging in such a scheme, defendants wrongfully acquire the property by fraud, undue influence, the violation of a trust, and other wrongful acts, and are not entitled to ownership of the property or of any of the assets in their possession acquired with the community property of plaintiff and D. Sterling. Plaintiff, together with D. Sterling, are the true owners of the property, which was purchased with community funds of plaintiff and D. Sterling, as alleged above, and are the true owners of all of the community property funds and assets and items purchased therewith, transferred to defendants by D. Sterling. By virtue of defendants' wrongful acts, they hold the property and all assets in their possession under their control acquired with the community property of plaintiff as constructive trustees for the benefit of plaintiff and the community. On information and belief, plaintiff alleges that defendants will transfer or conceal funds and assets unless a constructive trust is imposed. Imposition of a constructive trust is fair and equitable as between the parties in view of the unauthorized transfer of plaintiff's community property to defendants. The expectations of plaintiffs of joint control over such community property and defendants' knowledge that D. Sterling was at all times a married man who had not obtained the consent or authorization of his wife to the transfers of community property to defendants. Fourth cause of action, for community property had and received against all defendants. Plaintiff hereby incorporates by reference each and every allegation contained in paragraphs 1 through 28 as though fully set forth herein. On or about 2010 and at various times thereafter at Los Angeles, California, defendant Stiviano and does 1 through 50 became indebted to plaintiff for community funds and community property of plaintiff and D. Sterling in amounts unknown to plaintiff, but believed to be in excess of $400,000 provided by D. Sterling and received by said defendants at their request and without the consent and authorization of plaintiff. In or about December 2013 at Los Angeles, California, defendant Stiviano and does 1 through 50 became indebted to plaintiff in the sum of not less $1.8 million for community property provided by D. Sterling and received by defendants used to purchase the property and to pay expenses associated with the purchase of said property at their request and without the consent or authorization of plaintiff. Plaintiff is informed and believes and thereon alleges that D. Sterling has demanded payment from defendants on behalf of plaintiff. No payment has been made by defendants to plaintiff, and there is now due and owing the sum of at least $1.8 million, with interest on that amount at the current legal rate from December 9th, 2013, and there is now due and owing additional unknown amounts, but believed to be in excess of $400,000, with interest thereon at the current legal rate from the date each unauthorized transfer of community property was made by D. Sterling to defendants or any of them. Fifth cause of action for unjust enrichment against all defendants. Plaintiff hereby incorporates by reference each and every allegation contained in paragraphs 1 through 32 as though fully set forth herein. Defendants, and each of them, have received community property funds and assets that were provided by D. Sterling without the consent or authorization of plaintiff, and have wrongfully converted those funds for their own personal use. Defendants wrongfully used community funds provided by D. Sterling to purchase the property in the name of defendant Stiviano. Plaintiff is informed and believes and thereon alleges that defendants have converted additional community funds provided by D. Sterling, also without the consent or authorization of plaintiff, to pay their own expenses and to acquire assets in their own names. Defendants are unjustly retaining the benefit of community property funds and assets that D. Sterling transferred to or for the benefit of defendants without the consent or authorization of plaintiff, and at plaintiff's and the community's expense. As a direct and proximate result of the wrongful conduct of defendants, plaintiff has suffered and will continue to suffer damages in an amount to be proven at the time of trial, but including without limitation, A, 1.8 million in community property funds transferred by D. Sterling to or for the benefit of defendants used to purchase the property, and funds used to pay expenses associated with the purchase of the property without the consent and authorization of plaintiff. B, additional sums of community property transferred by D. Sterling to or for the benefit of defendants in an amount yet to be determined, used to acquire assets in the possession, custody, and or control of defendants without the consent or authorization of plaintiff. And C, additional sums of community property transferred by defendant to or for the benefit of defendants in an amount yet determined, used by defendants to pay their expenses without the consent or authorization of plaintiff. Sixth cause of action for an accounting of community property against all defendants. Plaintiff hereby incorporates by reference each and every allegation contained in paragraphs 1 through 36 as though fully set forth herein. Plaintiff is informed and believes and thereon alleges that defendants, and each of them, have possession of and or converted community property funds and assets transferred to them or for their benefit by D. Sterling without the consent or authorization of plaintiff. The exact amounts of the community property of plaintiff and D. Sterling transferred to defendants and or expended by defendants for their own personal uses are unknown to plaintiff and can be determined only by an accounting. Plaintiff seeks an accounting of all community property funds and assets transferred or paid by D. Sterling to or for the benefit of defendants, including an accounting of all real property and personal property, vehicles, jewelry, furniture, art, clothing, and other items acquired with community property funds, and the profits and rents therefrom. Seventh cause of action, to quiet title against all defendants. Plaintiff hereby incorporates by reference each and every allegation contained in paragraphs 1 through 39 as though fully set forth herein. Plaintiff and D. Sterling are the true owners of the property located at 8837 West 4th Street, City of Los Angeles, County of Los Angeles, State of California, 90048. The legal description of the property is as follows. Lot 8 in Block 43 of tract number 7SSS in the City of Los Angeles, County of Los Angeles, State of California, as per the map recorded in Book 88, page 79 to 84, inclusive of maps in the office of the county recorder of said county. Accepting, however, and accepting to said grantor the exclusive possession and the use and enjoyment in his own right of the rents, issues, and profits of said real property for and during the term of his natural life, and further accepting to said grantor the right to revoke. Plaintiff and D. Sterling's right to title in the property is based on the fact that the property was purchased with community property funds provided by D. Sterling and gifted to Stiviano without the consent and authorization of plaintiff. Plaintiff would not have consented to or authorized the use of community funds for any such purchase of the property for defendants. Plaintiff seeks to quiet title against defendants and all persons unknown who claim legal or equitable title, right, or interest in the property as of December 9th, 2013, the time at which, upon information and belief, D. Sterling purported to gift the property to Stiviano and defendants, wrongfully and or fraudulently caused title to the property to vest in the name of defendant Stiviano. Plaintiff also seeks to quiet title to all other property, real and personal, whose identities are presently unknown, but for which this complaint will be amended when the identities of such properties is ascertained, transferred by D. Sterling to defendants, or purchased by or in favor of defendants with community property provided by D. Sterling, all without the knowledge, consent, or authorization of plaintiff. Eighth cause of action, reformation of deed against all plaintiffs. Plaintiff hereby incorporates by reference each and every allegation contained in paragraphs 1 through 44 as though fully set forth herein. Plaintiff is informed and believes and thereon alleges that D. Sterling entered into an agreement with defendant Stiviano that the property would be purchased on behalf of the community and that title to the property would be vested in the names of plaintiff and D. Sterling, but that defendants wrongfully caused legal title to the property to vest in the name of defendant Stiviano and that D. Sterling purported to gift community funds to or for the benefit of defendants to purchase the property without obtaining the consent or authorization of plaintiff, and that defendants knew that D. Sterling's wife had not consented to or authorized the use of community property funds to acquire the property for Stiviano's benefit or in her name. Let me stop here and interrupt because what you don't know is I totally lost the picture there with the internet. So first I lost the picture for the complaint, then I lost the picture for me. So I had to go back and re-record paragraph 47 forward, like the last 10 minutes. You can hear audio and you can see the wording there, the Ms Legalista that's playing in the background. And that is it. No picture of me, no picture of the complaint. So I'm interrupting this to let you know that sometimes there are these struggles that are going on that cannot be helped. We've got this new 4G, I don't know, whatever it is. I'm not happy about it. It's not working. It's cutting out on me all the time. It is not consistent in providing internet service. And if anybody thinks I'm going to give it a good review, they are mistaken. They are sadly mistaken because I'm frustrated with it. All right, let's pull back up this complaint because that's what we're here to talk about. We're going to go back to this complaint now, and I hope everything is looking clear because as you saw, I started to get fuzzy there. Didn't I start to get fuzzy? Weren't you looking at me going, what is going on with Ms. Legalista there? Because that is not looking like her. All right, so we were finishing up paragraph 46. We are now on paragraph 44. And I'm just going to check back on this to make sure I'm looking good. So I can't really tell here. If I click back on it, let me see here. Like it doesn't say anything. It just says recording. And part of it is I cannot see that. And so I guess every once in a while I should click back over just to make sure. I'm too busy looking at this complaint. That's what I'm doing. I'm looking at the complaint. These acts contravene the agreement between D. Sterling and defendant Stiviano. Therefore, the grant deed as recorded does not presently express the intentions of the parties due to the agreement and should be revised so as to express that intention by changing the name of the title holder from defendant Stiviano to plaintiff and D. Sterling, husband and wife, as community property. Defendants did not provide any consideration for the purchase of the property, the purchase money having been provided by D. Sterling from community funds. This constitutes a failure of consideration and fraud by the defendants with respect to the grant deed to the property. The recordation of the grant deed was grossly unfair and unconscionable to plaintiff, as all funds used to acquire the property was community property of D. Sterling and plaintiff, and the transaction was consummated without the knowledge, consent, or authority of plaintiff. Plaintiff will suffer substantial harm and injury if the grant deed to the property is not reformed, in that plaintiff will be deprived of the normal rights and benefits of ownership of the property and will be unable to exercise her right to sell said property to third parties. Plaintiff hereby demands that the grant deed to the property be reformed to correctly name plaintiff and D. Sterling, husband and wife, as community property, as owners and title holders. Ninth cause of action: declaratory relief against all defendants. Plaintiff hereby incorporates by reference each and every allegation contained in paragraphs 1 through 50 as though fully set forth herein. A dispute has arisen and now exists between plaintiff and defendants, in that plaintiff contends that the community owns the property, the 3 automobiles purchased by D. Sterling for defendants, and all funds and other assets transferred by D. Sterling to defendant Stiviano in 2010 through the present date without the consent or authorization of R. Sterling, and all assets acquired by defendants with such funds transferred to them by D. Sterling, and that defendants have no right, title, or interest in the property, the automobiles, or in the community funds and assets transferred to them by D. Sterling, to the exclusion of plaintiff's community property interest. Plaintiff is informed and believes and thereon alleges that defendants contend that they are the owners of the property, the automobiles, and all funds and assets transferred to them by D. Sterling, and that plaintiff and the community have no ownership interest in same. Plaintiff desires a judicial determination of her rights and a declaration that the community property interest in the subject property, funds, and assets is superior to that of defendants, and that plaintiff currently has a community property interest in all such funds, assets, and property identified herein above. A judicial determination is necessary and appropriate at this time under the circumstances, in order that plaintiff may ascertain her and the community's rights in the property and assets transferred by D. Sterling to or for the benefit of defendants, and to settle the uncertainty of plaintiffs and the community's rights in such property and plaintiff's duties with relation to such property. Plaintiff is informed and believes and thereon alleges that any rents and income from the property and from any assets or property acquired with monies transferred by D. Sterling to defendants without plaintiff's consent or authorization is the community property of plaintiff and D. Sterling, and that defendants do not and have not acknowledged plaintiff's community property interest in all such property and the rents and income from same, to plaintiff's detriment and damage, in a sum to be determined at time of trial, and additional damages according to proof. 10th cause of action: declaration that gifts of community personal property are void against all defendants. Plaintiff hereby incorporates by reference each and every allegation contained in paragraphs 1 through 56 as though fully set forth herein. Plaintiff is informed and believes and thereon alleges that between February 2010 and the present date, D. Sterling attempted to make gifts of community cash and property to defendant Stiviano, including community funds used to purchase the property and the 3 automobiles, and transferring title to said assets to defendant Stiviano. These attempted gifts were made without the consent and authorization of plaintiff. Plaintiff has not since consented to the making of any gifts of community property to defendant Stiviano or defendants Does 1 through 50. Pursuant to these attempted gifts, D. Sterling delivered cash, checks, and personal property to defendant Stiviano and purchased assets for Stiviano with community funds. Defendants still have possession of the alleged gifts to the extent said funds have not been dissipated by defendants. Prayer for relief. Wherefore plaintiff prays for relief as follows. Under the first cause of action, for the set aside and return of all community property funds and assets transferred by D. Sterling to defendants, and all items acquired by defendants with such community property, including without limitation the property, to plaintiff on behalf of the community. under the second cause of action for damages according to proof, including general, special, and compensatory damages in the amount of the value of the community property converted by defendants, believed to be in excess of $2.5 million, including the $1.8 million in community funds provided by D. Sterling and used to purchase the property, for interest thereon at the legal rate. Under the third cause of action for imposition of a constructive trust, and for defendants to 1. Return the property to plaintiff on behalf of the community, 2. Return to plaintiff all community property funds and assets provided by D. Sterling for any purpose whatsoever to defendants, and all assets acquired therewith to plaintiff on behalf of the community, 3. Return the 2013 Range Rover, 2012 Ferrari, and 2 Bentley automobiles purchased with community funds to plaintiff on behalf of the community, and 4. Return all rents and profits from all such property to plaintiff for the benefit of the community. Under the fourth cause of action for general and compensatory damages believed to be in excess of $2.5 million, according to proof at time of trial, for interest at the legal rate from and after each date upon which defendants received community property funds and property, including the community property funds transferred by D. Sterling and used to purchase the property in December 2013. Under the fifth cause of action for general and compensatory damages believed to be in excess of $2.5 million, according to proof at the time of trial, for the return of the property to plaintiff on behalf of the community, for the return to plaintiff on behalf of the community all community property funds and assets provided by D. Sterling to defendants, all items purchased by defendants with such community funds, and all rents and profits from same, for interest thereon at the legal rate. Under the sixth cause of action for an accounting between plaintiff and defendants, for an order for payment to plaintiff by defendants of the amount found to be due plaintiff as a result of the accounting and interest thereon at the legal rate. Under the seventh cause of action to quiet title to the property, such that plaintiff and D. Sterling, husband and wife, as community property are recognized as the title holders with full rights to the property, including the right to possession. Under the eighth cause of action for the grant deed to the property to be revised to remove defendant Stiviano as the record title holder to the property and to substitute plaintiff and Donald Sterling as husband and wife as their community property as record and beneficial title holders to the property, and for the deed to be re-recorded to reflect such substitution. Under the ninth cause of action for a declaration that plaintiff has a community property interest in the property and in all community property funds and real and personal property acquired with community funds of plaintiff and D. Sterling in the possession, custody, or control of defendants, for general and compensatory damages believed to be in excess of $2.5 million, according to proof at time of trial, for interest thereon at the legal rate, for issuance of a temporary restraining order, a preliminary injunction, and a permanent injunction enjoining defendants from transferring, encumbering, or divesting any interest in the property pending a final judgment in this action. Under the 10th cause of action, a declaration that the attempted gifts of funds, assets, and real and personal property by D. Sterling to defendants are now and at all times have been the community property of plaintiff and D. Sterling. A declaration that the attempted gifts of community property to defendants are void under all causes of action for issuance of a temporary restraining order, a preliminary injunction, and a permanent injunction enjoining defendants from transferring, encumbering, or divesting any interest in the property pending a final judgment in this action, for costs of suit incurred herein, for attorney's fees and costs to the extent permitted by law, and for such other and further relief as the court deems just and proper. And this was dated March 7, 2014, signed by Amiel Rice, Esquire, attorneys for plaintiff, and the firm was Wasser, Cooperman, and Carter. Then after all that, you have the verification, which was signed by Rochelle Sterling, and then you have the actual deed that they have been discussing in here for the property. The grant deed, as you can see there, for a valuable consideration, receipt of which is hereby acknowledged from YZ Homes LLC, and it says it's to V. Stiviano, a single woman, and you have the address there. So that pretty much wraps it up. The only thing that's left there would be the recording cover sheet for the actual lawsuit. And that is a lot. Like I said, my stuff cut out earlier, so I had to redo this last part of the video. But if you have been watching the show, let me know your thoughts on now knowing behind the scenes what was in those papers, the cars, the property. And we knew some of that from the show, but I think it is a little bit more telling to actually have the document in front of you, see what the document says, and understand what was going on for real, because we do know that a lot of times these fictional dramatic accounts have been reworked a little bit for dramatic purposes in order for them to be a little bit more entertaining. And entertaining, I do think it is. So go ahead and give the video a thumbs up if this helps you understand what the wife was laying out in terms of her strategy for getting her property back. This was the way she went. There you go. Give the video a thumbs up and don't forget to subscribe and check out some of the other videos that I'm going to be doing about this topic as it relates to the show on whatever channel that is. Peace.